everyone, and welcome to the second episode of Trust Issues, our official podcast series for the FairSquare Competition Law Society. Founded under the guidance of our Honorable Vice Chancellor, Dr. G.S. Bajpai, and our faculty advisor, Dr. Abha Yadav, our society aims to foster academic discourse and analyze the evolving dynamics of antitrust and market regulation under the Indian competition law regime. Today's episode focuses on a critical yet unexplored pillar of competition law in India, which is that private enforcement of competition law. While public enforcement through the CCI aims to penalize violators for infringing and their anti-competitive behavior, private enforcement aims to foster and to provide affected parties and other victim parties to compensate for the losses they've suffered under the infringing behavior. To help us navigate through the complex legal and economic perspective of private enforcement in competition law, we are honored to have joined us today Mr. Shashank Sharma, Policy Head at Axiom 5, a leading boutique law firm specializing in competition law policy and issues in India. Shashank sir has spent over a decade in this field with rich expertise in competition law and economics law. His doctoral research also focuses on competition law issues. He is also a dedicated academic offering a comprehensive course on competition law and policy at his alma mater NLS Bangalore, as well as right here with us at NLU Delhi. Welcome to the podcast, sir. Thank you so much for being here with us today.
Thanks for inviting me. And I must first of all credit you guys for this very professional setup. And I must say I have been ambushed into a video interview here. So I look the way I look. But first of all, it's a very good initiative because usually when academic centers, start any initiative like this, usually very cut and dry, it appeals only to other law students and other law professors. But I understand that this, when it goes out in the world, it might appeal to a slightly more, a slightly wider audience, which is competition law. As somebody who's done competition law a lot, it's, the more people are aware of it, the better it is for the country overall, I would say. But yeah, I'm happy to talk about the issue of private enforcement today, for which I've been asked. And hopefully I'll shed some light.
Yeah, definitely, sir. I think to begin with, looking at the current status of private enforcement under the Competition Act, it has been in the books since 2009, yet there is no single compensation claim that has been finally adjudicated in India. In your perspective, what, according to you, could be the root cause of this long-standing inertia?
Yeah. So, like many of life's bad things, there is not one root cause here. It's not monocausal. If I had to say the immediate trigger for lack of even litigation activity when it comes to private enforcement is there is no finality of adjudication for a lot of competition law cases in India so far. So when I say finality of adjudication, I mean, the CCI has passed an order, the NCLAT, the National Company Law Appellate Tribunal, has heard the appeal, and then the Supreme Court has also heard the appeal from the NCLAT order and passed a final order. Right now, what has happened is the NCLAT so to step back a bit, how does the private enforcement regime in India work? We call it private enforcement, but it is slightly different from the strongest meaning of the term private enforcement. What we have is a follow-on compensation model, right? There are regimes outside the jurisdictions where there is genuine private enforcement, as we call it. You can just go and sue a company for breach of antitrust statutes in a court. The US is a prime example of such a jurisdiction. India is not one of those, nor is the European Union. The UK is an interesting mix. They also have standalone private enforcement actions now, which is still, I think, a less than a decade old regime, even in the UK. But in India, what we have is follow-on compensation. Follow-on, implies that it follows on from a decision. Usually, even just statutorily, it has to follow after a finding by either the Commission or the NCLAT. In practice, what it has meant is that the NCLAT, which is the natural seat for hearing an application for compensation, has not taken up matters so far as they're pending at the Supreme Court, because their reasoning goes, what's the point of engaging in all this, mathematical quantification exercises for damages when, the Supreme Court might actually overturn the finding of infringement in the first place. So here we are stuck in this, limbo where there is a lot of litigation delay at the Supreme Court level, and because there is no finality of adjudication, there is nothing really substantive to follow on from. So the NCLAT is playing it a bit safe. Also doesn't help that the NCLAT is also, understaffed when it comes to matters of competition, in competition hearings. There is no dedicated competition law bench. There have been proposals floated at various times, but we still don't have one. So that's I would say, just the statutory and the legalistic problem behind it. The second is also the incentive problem, so to say. I would say the legalistic problem, I think, is the immediate real bar. That's why you don't really see too many, follow-on compensation applications being filed at the NCLAT. The second is the incentive structure, right? Why would you go ahead and file a compensation application? Who's going to file a compensation application? Well, usually under the Indian law, and this is true of European law, this is actually true as a matter of principle of antitrust, private enforcement generally. People affected, right? People who are aggrieved, fair enough. Now, there are two kinds of, we might have discussed, because I've been teaching competition law in NLU Delhi this semester. So there are two kinds of, exploitative conduct under antitrust and exclusionary conduct under antitrust. Now, when it comes to exclusionary antitrust, exclusionary conduct, you can sometimes find fairly strong commercial parties which might be harmed. Right, if it's a kind of a contractual restraint which bars significant, substantial competitors from actually competing effectively, and in the end the finding is that yes, there was anti-competitive exclusion, then those companies are big enough, sophisticated enough, they can hire their fancy lawyers, and their economists, and claim a certain, this is my compensation, this is what I was due, this is what I am due, and you should pay me. That's one angle. The second is what we call exploitative harm. Now, this, by its very nature, is very disaggregated and diluted across a large number of people. So when you talk about, if it's a cartel think of what is a cartel. If it's a cartel which affects prices of goods which are consumed by a large number of people, right? It's going to be difficult for you to get. Why would you go and file a complaint if, the amount due to you might be 100 rupees, right? So we call it so that is a coordination problem. Now, what does not help is that we don't generally have a culture of class action litigation in India, period. It's not just an antitrust specific issue, right? You might not have heard, in the US, for example, you hear these massive class action lawsuits which either get settled or decided by a jury, which pay out enormous sums to litigants. You barely ever hear this in India. And the reason is structural. The Competition Act does allow for representative suits. So you can call them, the competition class action lawsuits, if you want to call them that. But it's still a very curtailed regime compared to, let's say, the US. Here, it's practically an opt-in regime, as we call it. So a class is, to compare it to the UK now, the UK is more of an opt-out regime. So what does that mean? It means that if a bunch of litigants, or if just one litigant, affected party, goes to the court and says, I'm here to represent a class, and I define the class in a certain manner, the UK Competition Appellate Tribunal would say, you know what, I think you're defining the class well. All members of the class are hereby, reduced to this matter, but unless they specifically seek an exclusion from this class. In India, it's a bit different. Practically, what happens is that unless you get a bunch of people to actually affirmatively join your action, it's not going to fly. Now, there are some granularities there, but this is practically what the situation is. What also doesn't help is, and this need not happen, but you don't have, unlike in the US, contingency fees for lawyers, right? Lawyers have no incentives to take on speculative matters where they're not going to get paid. In the US, you can just get paid a percentage of your fees, right? A percentage of the final damages awards which a class might get. So let's say somebody in the US, a law firm in the US, sues on behalf of a class. The class gets 100 million, either compensation or a settlement amount. They'll take a 10% or a 15%, right? That's illegal under Indian, I think, the Bar Council ethic rules. That's not allowed, which is fair enough. That's its own kettle of fish, as we say. There are other jurisdictions which have similar ethics rules, but they have slightly different market-based solutions. So what we call third-party litigation financing. That is also almost non-existent in India. My arbitration friends might, disagree, but as far as I'm aware, third-party litigation financing in India is very, very rare, and it's I would not even call it it's in infancy; it's in its fetal state. Okay, and the reason for that is very simple. Again, what we have in India is a legal culture, a litigation culture, which is very long drawn usually. Right. So you see matters drag on for 15, 20, 10, 15, 20 years. Even in competition law cases, we already see cases which have been pending final adjudication for 15 years. Right. Now think of it from the point of view of a third party litigation funder. Their entire incentive, they're not doing it out of the charity of their heart, right? The reason they do it is because they anticipate, okay, I'm going to invest a certain amount of money. And when the case is finally decided, I anticipate with a certain probability that I'm going to get paid a certain amount. So I can make that calculation at this stage and come to a certain whether to fund or not to fund decision. But it becomes very, very difficult when the time horizons involved are very, very long. This is what we call the time discounting effect, right? Like $100 15 years from now is not the same as $100 5 years from now. So that is another big factor. So you have the legalistic hurdles. You have the incentive structure problem also. Now, I don't know what the great solution to this is. Maybe it'll have a sort of a snowball effect that if one or two matters start, you might get momentum from everybody might start to join the bandwagon. It might happen, might not happen. But so far, this is, I would say, overall, this is the picture. This is why we are in a bit in the doldrums when it comes to private enforcement. You also, just to add one thing, you talked about the role of private enforcement being more compensatory, which is true.
Yeah.
Under Indian competition law, even under EU competition law principles, the principle is compensatory. But one of the effects of private enforcement, and right now when I'm going to use the term private enforcement, just please understand it to mean follow-on compensation claims, right? Follow-on compensation or damages claims. One of the effects is also deterrent, right? The side effect is deterrence too. If I'm a company no company decides like this, but let's just, for the purpose of simplicity, assume if I'm a company which is about to infringe or not to infringe, that's my decision, right? What will I look at in the terms of the cons of an infringement? Obviously, there could be a penalty that you can kind of factor in based on your profit revenue. But you also would have to take into account the amount of damages you might be liable for. In fact, in the US, where the damages are trebled by law, the damages is actually, is the main driver of deterrence too. Well, the US doesn't have penalties as such because it's, again, private enforcement, pure private enforcement there. But because we do not have a culture of private enforcement of follow-on damages in India, that limb of deterrence is also gone. So, you don't have that anymore. That has, I would say, it leads to a problem of under-enforcement or under-deterrence, you can say. But yeah, I think, I hope that answered your question, but it is.
Yeah, that actually explained a lot of in-depth about all of the issues that are currently facing the betterment of private enforcement. I just wanted to get in detail about this coordination problem, as you mentioned, between indirect purchasers. So the hurdle around that is that in compensation claims, the calculation of it and proving that an affected party is entitled in the first place for compensation is complex as it is. What now happens is, if we look at a global perspective, while the US bars indirect purchasers or the direct or like the final consumers from making actionable claims, the European Union and India have this, as you also talked about, have allowed for indirect purchasers and final consumers to make these claims. As you said, that these can be through class action suits. I just wanted to ask, like, how would that calculation and how would proving that such nominal overcharges in certain cases to final consumers would look like in a compensation claim?
Okay, so I think just to clarify a few terms for the general audience, when you talk about the indirect purchaser rule, what we understand is that, let's take the example of the US. In the US, if there is a cartel, for example, right? If the cartel has overcharged, that is, it has charged a certain sum above the competitive price level, then the immediate purchasers, right, people who purchase directly from the cartel participant, can claim that entire delta, right, that X amount. Nobody else can, right? So what we say is the US bars suits from indirect purchasers. So it's no defense to say that, okay, Mr. You bought from me, I'm a cartelist, fair enough. You bought from me, fair enough. You paid X extra amount, fair enough. But you also pass that off to your immediate, to your further seller or further purchaser. Uh, so we should also be allowed the defense of what is called a passing on defense. That is, honestly, Mr. Immediate Purchaser, I should not be liable to pay you X, but rather only X minus some delta X, which is the amount you passed on to the your own purchaser. The US doesn't allow that. The US bars what we call the indirect purchase. It's also called the, for people who are interested, the Illinois brick doctrine, right? And the passing on defense was kind of eliminated under the Hanover shoe case by the SCOTUS, the Supreme Court of the United States. In India, well, India is, I would not even talk about India directly because we don't have any jurisprudence. But you're correct. If you read the statute, it would imply that we are more in the European position. European Union, the damages directive, does not bar indirect purchases from claiming compensation. It also does not bar the passing on defense, right? Which would make sense, right? Because otherwise you would have a situation in which two purchasers, a direct and indirect purchaser, might actually claim a compensation which is more than what the person was even enriched by, right? So it'll be a case of over enforcement, if you want to call it, or over compensation. There are a lot of technical problems with it. You're right. It becomes a quantitatively way more complicated exercise than the US. Because in the US it's simple, right? Well, it's relatively simple. You go, okay, this was the overcharge of the cartel or any abuse of dominance case. Like I'm using cartel as an example. You paid this X amount extra. So, okay, you just pay me back that X amount into the number of, the units you sold to me. And then you also look at something called the volume effect, which is the lost sales, which I might have had because of higher prices. But it's a relatively simple calculation. But when it comes to indirect purchasers, when you account for both of them and including the passing on defense, then you have to say, okay, you got it for X rupees or X dollars extra, but then you passed on a bit of this cost increase to your indirect purchasers, who in turn might have passed it on to their indirect purchasers, right? So it becomes very difficult to actually make this calculation. So quantification becomes a problem. There are methods to do it. People have done it. What is also important, though, is more than the quantitative or the calculation problem, is an incentive problem. The US example does motivate the immediate purchaser a lot more, right? Because he has a credible claim for an entire amount of the overcharge. That actually induces way more compensation claims, or at least incentivizes them way more strongly than this incentive, which is now is weakened and diluted across a large bunch of disaggregated players across different layers of the purchasing chain. So who's to say? I think the US example is useful. It does undercompensate. You're correct. You are not getting the indirect purchasers who might have been victims are not getting the compensation, so to say. But it also does encourage the immediate purchasers to actually claim compensation, which in turn has a deterrent effect. So this is more of an empirical question. I don't think I will be able to tell you, or I don't think anybody will be able to tell you which is the superior regime in many cases. There are different goals at play in some places. If you look for pure deterrence, then maybe the US example is a bit better. But then in the Indian and the European context, for deterrence, you also have penalties, which is not present in the US case, right? So it's, how do I say, it's actually a calculation or an empirical problem at its core. So I hope that answered your question somewhat.
No, that helps. I was actually thinking about how you mentioned that in US the immediate purchasers or the direct purchasers have a credible claim. So this is also something that raises a curiosity for me also as a law student, is that one thing is about the passing on defense and the indirect purchaser or final consumers having a claim. The other side is that direct purchasers, especially because it's allowed technically under the Indian Competition Act. So would that lead to a situation where both, because if indirect purchasers also make a claim, and then side by side if there's a claim by immediate purchasers, would that cause a situation where the immediate purchasers can claim like overcharge despite having a despite having final consumers having the claim?
So to answer that, I think it again going to be a bit of a lawyerly answer, sadly. It's going to be depends, right? Because the tribunal, which is going to be hearing the compensation application, is going to hear submissions from all parties. And in the end, it's their job to calibrate how much of the overcharge was actually passed on. So it's just no defense for the immediate purchaser in the Indian context or the EU context to say, just give me the entire overcharge. That's not going to fly. The tribunal is going to say, okay, from based on what has been presented to us, we note that 50% of what you got as an overcharge you passed on to your purchaser, the indirect purchaser in this case, and they can ration out the compensation accordingly. So it's a calculation problem. I don't think it's an unsurmountable problem of an incentive structure. I think it's just a calculation problem in the end. There'll be an apportionment of the overall overcharge across the direct and the indirect purchaser. Yes.
I wanted to ask if so. In November 2024, the CCI issued a landmark order against Meta and WhatsApp regarding its 2021 privacy policy. And this case established privacy as like a non-pricing parameter for competition infringement. And we see that such cases are also on the rise, especially digital and zero price digital competition cases, or in digital zero price markets where pricing is not an issue, so there is no actual monetary loss suffered by the purchasers. And how would private enforcement look in that kind of situation where the infringer is a company who is offering a non-priced behavior or like a non-pricing digital?
Fair enough. So this is a topic which is slightly closer to my heart. It's also my thesis also deals with a few of these issues. But just to step back again, when you talk about private enforcement or follow-on compensation claims in the case of zero price markets, one thing is clear, right? The exclusionary harm or the exclusionary anti-competitive harm, that is not really affected by the zero price nature of these products, right? Because they are affected that the competitors of these companies which are offering zero price markets or zero price products are being affected. They're being excluded. So there again, there are computational problems, but there is no unsurmountable computational problem. It's, what is the loss of profit suffered by competitors who have been anti-competitively excluded? There are benchmarks you can use, to try and calculate. That's one. Where it becomes interesting is what you'll say exploitative abuse of end customers, right? So you and me. So in the WhatsApp case, for example, you'd say end users of WhatsApp, Now it becomes really tricky when it comes to zero price markets, because while it's very easy to say privacy is a non-price parameter for competition, and that has been unfairly hurt by certain conduct by a certain company, so we should be, and that's true. If you say that there has been a theory, you can't say that somebody has been harmed and then turn around and tell them that there is no quantification of such harm. It's a bit of a problem, right? And alas, what I think is that this is actually still I will not say a legal vacuum, but conceptually there is very little clarity on this so far globally. In fact, as far as I know, there is no case where a zero price market, an exploitative abuse of dominance in a zero price market has actually led to a successful compensation claim. There is one which is ongoing on very similar fact patterns in the UK, a class action lawsuit. It's called Gomson versus Meta. I think it's set for trial in next summer, sometime in 2027. And I'll come to, there is a slightly novel methodology that they come to use. But the problem here is competition law damages or antitrust damages, as we understand, are in the UK and in India and in the EU are compensatory, right? They are meant to compensate you for the harm you have suffered. Now, you'll go around and say, okay, my privacy has been denuded for some reason, has been degraded. Okay, fair enough. But how do you quantify that? Now, there are people who say, I'll do a survey. I'll say, how much do you value your privacy? But now this leads into one of the most famous results in behavioral economics literature, right? The privacy paradox. People almost regularly inflate what they say or inflate their sense of what their privacy is worth to them, vis-a-vis when it actually comes to market conduct, they don't show it at all, right? So essentially, people say they value privacy more than they actually do. If you want to caricature that line of research in like one sentence. So that becomes a problem. Or in economics, what you call, the difference between stated preferences and revealed preferences. Usually, economic literature follows the revealed preference route when it comes to quantification of somebody's valuation, because stock is cheap, as they say. Uh, so that's one problem. So how do you quantify it in terms of, it can't be just user reported valuations, right? Because that leads to a great problem just in terms of conceptually at the bedrock level. Then the second problem is, and there's somewhat less of an unsurmountable error problem, is that different people have different privacy valuations, right? You might value a privacy in a slightly different way than I do, but fair enough, that's kind of true for a lot of things when you're looking at a huge class of people. Maybe you can average it out, whatever, but that's another reason. Another problem with digital markets, especially, is the product keeps changing, right? The product, so think of it this way. I'm going to take the example of WhatsApp only, let's say, right? WhatsApp 10 years ago was very different from WhatsApp of like 2 years ago. Now, imagine you were paying 0 rupees then or $0 then, and you're paying $0 now, right? Can you say that you have been paying the same? Is it the same product anymore? Don't you have way more features, right? So how are you going to actually, so okay, let's say thought experiment. At some time, let's say the trade became unfair, right? That the amount you were giving up in privacy was more than the value you were deriving from it. If that's not the case, then there is no case at all, right? So it has to be, that's the strongest case you can make. Okay, so when did that happen? So it's just because the product bundle in this question, the product in this question is so quick, it changes so quickly and iteratively, it becomes difficult to even nail down the quantum of overcharge. Even if you want, like, forget the conceptual problem of calculating the quantum of overcharge, using privacy as a metric, it just becomes very difficult. How are you going to do it? Now, there have been attempts made. Some people have done this by saying, okay, this company makes so much profit from our data. That's the usual line, fair enough. But that's not a measure of compensation. In competition law in India and in the UK, we can claim compensation for losses suffered. We can't claim gains made by the offending person, like, at least under the current status of the law. Now, if you do come up with a legislative amendment and change the rules, that's fair enough. That's a different conversation. But within a compensatory framework, you can't just allude to a company's profits and say, okay, look, these guys made so much profit, let's just give me a percentage of it. That is not conceptually robust, right? Now, if you want to make it conceptually robust, you can just come with a legislative amendment and make it so, right? Fair enough. But as far as our current understanding of the law as it stands, that's not allowed. In fact, the Gomson versus Meta class action, which I talked about in the UK, this was one of the first reasons that the initial application was rejected. The class certification application was rejected because the tribunal in that instance says, you know what, you're actually claiming disgorgement, which is essentially recoupment of profits made by, or what you call unjust profits made by Meta in that case. But that's not a standard for compensation under antitrust competition law. Then they came back with a new methodology, and this is it's fairly novel. What they used, and the methodology which has been proposed, is what is called a loss of a bargaining model, so to say, which is usually used in the context of IP rights sometimes. So that this class would have gained something had they been allowed to bargain, and this was not allowed to happen. I'm not going to it becomes a bit too subtle, so I'm not going to bore people with the details. I encourage you to go and read it. It's interesting. But essentially what it talks about is that the class as a whole lost a chance to bargain with, in this case, Meta, or you can use the methodology elsewhere. And that's the loss of the bargaining chance that we want to quantify. Now, again, this unsettled law. This has never been used before. This kind of methodology has never been used before for competition law damages. There are empty number of problems with it. I'm happy to talk about the matter at a slightly, more, more academic setting in many ways. But so this is what to tell you, this zero price markets compensation is not that easy a nut to crack. It is difficult. It's a difficult problem for many reasons. It's a difficult problem from the point of view of computation, but also conceptually. To step back and to make it a bit broader, it's in fact the entire concept of exploitative abuse of non-price exploitative abuse, let me put it that way, non-price based exploitative abuse of dominance itself is a bit tricky when it comes to calculating damages. When you say somebody imposed unfair terms and conditions in an abusive manner, okay, how do you quantify that? What's the valuation of an unfair term? it's not the same as saying excessive pricing, right? Excessive pricing, you can say, okay, maybe there was some delta I can, try and calculate, which is its own kettle of fish, but whatever. In this case, how do you quantify the value of just one unfair term? Can you? We have the example of, the DLF case in India, where there were, the DLF was set to abuse its dominance because it imposed certain one-sided unfair terms on its, purchasers. Okay, fair enough. How are you going to quantify it? In fact, competition authorities are a bit wary of this for the same reason. For as far as I know, the German cartel office, when it penalized Facebook for on the similar WhatsApp kind of a fact pattern, they did not go ahead and call it excessive pricing for that reason. They just left it at unfair terms because this has not been settled anywhere. And interestingly, and there is a comparative law angle to it, the reason this has not been settled is because the most damages happy regime in the world, which is the US, doesn't recognize exploitative abuses. So there is no test case there, right? So because they don't recognize exploitative abuse or dominance as a concept, essentially, what you have is a complete lack of any action in what is otherwise the most active jurisdiction for, damages calculations. So I hope that answered your question a bit.
I think definitely so, because quantification is definitely an issue. There are other procedural issues and conflicts within competition law. One of which is that, of course, the Competition Act now offers settlement and commitment mechanisms for entities. While this is a significant step forward for judicial efficiency, it also introduces a major conundrum maybe for private enforcement. Let's say if an enterprise enters into a settlement with the CCI, does that agreement or admission of that guilt that they are infringing and they will now settle for such amount, would that contain actionable evidence for a compensation claim against that entity?
Yes. So as far as I know, you're not supposed to use the evidence which has been submitted as part of your settlements and commitments applications, to bolster your. In fact, we need to separate settlements and commitments here a bit differently, because in commitments there is no finding of an infringement, right? Nor is there technically in the case of settlements. But settlement is a bit of a tricky area, and I'm not going to go too deeply into it for many reasons. One is that it's also not clear whether you can actually go for a compensation application just following settlements. The readings would say that you can, then I would say that there's no finding there either. So is the NCLAT going to be the arbiter of the infringement as well as the calculation problem or the compensation quantification? I'll park that aside. But when it comes to commitments, there is not even a finding of any kind, right? It's just clear cut. There is not even legalistically, there is not an ambiguity there. But again, you step back. What's the purpose of introducing settlements and commitments? The purpose of introducing a settlement and commitment regime is to, short circuit long drawn litigious, cases which go on for 10, 15 years. Now you're right. Somebody might say, okay, but I was my rights were infringed in an anti-competitive manner. I've been harmed. Why am I not being compensated? Fair enough. But you also have to look, when you design a system, you also have to look at the overall effect that system is going to have. There is genuine good which can come from an efficient settlement and commitment regime, because it can lead to market corrections quickly, right? It will lead to less wastage of resources of the CCI and the NCLAT, right? It will free up resources to actually focus on areas where these people are not coming up for settlements and commitments. So you can't. It's a balancing exercise, and in fact, I would suggest that anything which really dulls the impact of a settlement and commitment regime. For example, take a slightly absurd example. Let's say all commitment applications also were just automatically made liable for compensation. Who would come for a commitment then? Right? Similarly, if you make settlements automatically liable for compensation, who would come for a settlement then? Maybe somebody would, but you're just dampening the incentives for parties to actually use the tool that you yourself have bought, for more parties to use. So you can't have a system which, so let's put it this way. It's the same as leniency, right? I think in a leniency regime also, if you keep making the leniency applicants, wholly liable for whatever they have done, you can say, okay, well, you're not going to get the penalty, at least fair enough. But compare it to a world where they're also, the liability for compensation is also somewhat dampened, that's a way more attractive leniency proposition for a leniency applicant than a world in which, they're liable for the entirety of their exposure for a cartel infringement. So I think, I hope that answers your question to a certain extent, right? It's like when you're designing a legal system, you can't just look at one aspect. And I agree, the compensatory aspect will perhaps suffer. But then you don't know if there was going to be a finding of infringement at the commitment or the settlement level, right? That's just even the settlement is right after the DG's report, right? Commitment is even before that. There is no guarantee that the CCI would have found you guilty. There's no guarantee the NCLAT would have found you guilty. There's no guarantee that the Supreme Court would have found you guilty. And this would have taken 10, 15 years of the court's time, the NCLAT's time, the CCI's time, and, all the litigants' time, and the people would have been suffering, right? So maybe this actually short circuits that entire process and corrects the market really quickly. So yeah, you kind of lose the compensation angle a bit, but you gain a lot in terms of market efficiency and enforcement efficiency.
I think that makes sense also, because I wanted to probe you more about the leniency angle on that. And that was a follow-up question that I had. Do you think that also poses a slight conflict between private enforcement and leniency programs, considering that, for instance, EU in its damages directives mentions that leniency applications have a partial protection for civil liability and compensation claims, while that is absent in India? How do you suppose that the court or the deciding body goes on about balancing the leniency protection with private enforcement and compensation claims?
So see, I think you have two comparatives. We have a comparative example here, right? The EU and India. Just if I were to turn the question to you, which would you think would be more attractive to a leniency applicant? The EU regime would be more, right? Because they face overall less consequences for for going forth with a leniency application, compared to the Indian scenario where there is no written law allowing for such leniency within the leniency regime, so to say. The calculation is going to be, okay, you know what, maybe here my incentives are a bit dampened. Incentives to, file a leniency application are a bit dampened. Now, these are all relative and comparative issues in a way, right? Compared to a world in which there was no leniency application regime at all, obviously this is a better place we are in now. But can we actually tweak the leniency application regime to be a bit better? Yes. But again, we must be mindful that there is actually a compensation angle at play too. Right. So you see different legal systems using slightly different, they're tinkering with the variables. The EU has tinkered with the variables to say, you know what, I think we allow direct purchasers of a cartel participant still the right to seek compensation, but not everybody else. Maybe we could tweak something like that in India. But again, it's a system design issue at heart. Yes.
That sums up my trying to pick your mind about private enforcement. And I think before we wrap up, I just wanted to ask you a broader, more generic question about coming from as a law student and for our viewers and young professionals in the competition law field. What would your advice be to everybody, anybody interested in this field and trying to, just keeping up with competition law? What your advice would be and how they can try to keep up with it better for future changes?
Fair enough. So first of all, I might not look it, but I'm too young to be dispensing advice to people. But that aside, see, I'm not going to give you advice because everybody, learns at their own different ways. What I would encourage people to do, if you want to just follow competition law issues, just read newspapers. And nobody reads newspapers these days, I guess. But whatever avenues of news consumption you have, follow, you will see interesting cases, which even if you're not a competition law person, there are interesting cases. You read the newspapers, you'll see, okay, this seems like, or if you did a course in competition law as you did, taught by me, hopefully, things will rhyme in your head. So, okay, this is what professor was telling. Maybe this might be a bit interesting. So just be engaged generally. And second is, and this is not just competition law, but any lawyer, is just know when you do not understand something. Do not replace confusion with conviction, right? So you have to be sure that what you understand, you understand. And you cannot wordsmith your way out of clear conceptual problems. So, and there is all of us are guilty of it as lawyers. We sometimes think that we can, word our way out of a conceptual quandary. Sometimes you cannot. Sometimes the truth is actually binary, yes and no. It's not always, very rarely for lawyers to say though, but you can't. Essentially what I'm arguing for, and this sadly affects even the judgments we read, a certain amount of rigor in how you understand something, which hopefully will inform the way you explain stuff to people in turn. And hopefully once you guys are senior enough, it will reflect in the way you write judgments.
Definitely. I think keeping up with the law and reading anything that comes is
so just to add, like when you talk about competition law, you also have to be, it is a law which is obviously, it's a black letter law, that's true, but a lot of it is like an iceberg, right? When you read the text, it's like suppose the 10% above water. There is a lot of economic intuition and literature which is buried under the clauses of the Competition Act or the sections of the Competition Act. So unless you know them, you can't black letter read your way into a proper understanding of competition law. So if you don't understand basic economic principles, you're going to struggle to understand competition law properly. That's just the way it is, sadly. Thankfully, as I understand, most law schools in the country have economics courses. At least the BA, LLB ones do, as I understand. And you don't have to be an economist. Nobody's asking anybody to become an economist, right? It's a fairly rigorous field in its own. But unless you have a certain eye and an ear for what the economic intuition or the economic debates underlying a certain issue in competition law are, your understanding is going to remain superficial, right? You're not going to understand it deeply. So that's what I would say, that you need a certain amount of economic intuition when it comes to understanding competition law issues properly.
I think that helps a lot, and I think that brings us to the end of our discussion. Thank you so much,
thank
sir.
you. Thanks for having me.
Thank you so much for
and always welcome to be at NLU Delhi. This is a lovely initiative, you guys, I must say. It's also very professional. Sad.
Thank you so much, sir. Thank you so for sharing your insights. And I feel like if and when we do have a compensation claim that reaches final adjudication,
that reminds me of Faiz Ahmed Faiz's line, right? Nigah mein manzil nahi to justju hi sahi, nahi visal mayassar to arzu hi sahi. We live in hope. Let's see.
We can only hope that comes about. Thank you so much, sir.
Thanks.
And for our viewers, if you found our discussion today engaging, please like the video, share it with your peers, and don't forget to hit the subscribe button. Thank you so much for tuning in, and we will see you in more such episodes.